Last week we looked primarily at court decisions having to do with the First Amendment. The Establishment Clause that the federal government cannot establish religion, nor can they hinder the free exercise of religion, and trying to sort out that conundrum, what we looked at last week. The ones we're going to look at this week are a little bit broader, but they really talk about the interaction of religion and the state in areas other than the First Amendment. And the first of these goes all the way back to 1878, and the case was Reynolds versus the United States. This case focused on the question of polygamy. The Church of Jesus Christ of the Latter-day Saints was trying to get Utah established as a state. And in order for that to happen, the state of Utah, or the territory of Utah, had to make accommodations to its law. And the LDS Church decided, yes, since they have a prophet at the head of the church, the prophet could make the decision that we're going to change things now. I've got a new revelation, and polygamy is no longer acceptable, because the state had, or the federal government authorities in the government had made it very clear that Utah was not going to get into the Union until they banned polygamy. So 1878, Reynolds versus the United States, Supreme Court, the court ruled unanimously that a law banning polygamy was constitutional and did not infringe upon individuals' First Amendment rights to the free exercise of religion. So this group of polygamists in the LDS were basically saying it's our religious freedom to practice religion as we believe it, and that is for males to have multiple wives because it's their duty. It's a woman's duty to bear children, and it's a father's duty to father children, and women are physically limited to one child a year, but men aren't, so if we want to get more kids, we have to have more wives. Basically how the argument goes. The court concluded that people cannot excuse themselves from the law because of their religion. Can a man excuse his illegal practices because of his religious beliefs? That would permit professed doctrines of religious belief superior to the law of the land. And the Constitution, if we're going to be a nation of laws, the Constitution has to be the principle by which we follow those laws. So that was really, it really was an easy call to make. There's not going to be a lot of public outcry from the citizens that say, oh man, we can't have polygamy. Even those men who wanted to say it were smart enough, they didn't say it in front of their wives, and so the discussions went away, and it was really not an issue. It was an early court case ruling. Okay, the second one we want to go into, and this one, number 2 and number 3, and one we're going to look at a little bit later, all involve Lutherans to one extent or another. The case of Meyer versus Nebraska, 1923, was the question of children and education and church and religion. In the case of Meyer versus Nebraska, this was Missouri Synod Lutherans. And Missouri Synod Lutherans, at that time, every congregation had a school, even if the pastor was the one who taught the school. And they had a very extensive network of schools around the country. Nebraska this is post-World War I. And one of the areas I focused on in writing my dissertation was looking at discrimination against Germans during the First World War. And it was very bad. All kinds of examples. I got a number of them I wrote in my dissertation. In one church, I think it was in southern Illinois, if I remember correctly. It was a Sunday in October. It was Reformation Sunday. It was a warm day. They had all the windows open, and they were singing "A Mighty Fortress Is Our God," right? Of course, they're singing it in German because 90% of the German Lutheran congregation spoke in German. In German, "Ein feste Burg ist unser Gott," a mighty fortress is our God, sounded like a Hindenburg is our God, And so the people in town got riled up because they thought they were singing a song to the Emperor of Germany in the middle of the war. Again, so incensed that they had stormed the church and burned it down. That was one example of this, and there were other places where a number of pastors were forced to leave because they would only speak in German. And so state legislators began to say, it's a patriotic act that people should not be speaking German when we're in war with Germany. And the state of Nebraska was one of the states who passed an English language only referendum. So in Meyer versus the state of Nebraska, can the government regulate what children are taught even in private schools? Does the government have a sufficient rational interest in children's education to determine exactly what that education encompasses, no matter where that education is received? So these were church schools. The schools were completely supported by the congregations. And contrary to what's going on today, churches did not charge tuition. The members of the congregation supported both the church and the school. So it was a completely private school, and in that private school, they were still teaching in German. State came in and said, no, you can't do that. The court decision, the question before the court was whether or not the law violated people's liberty as protected by the 14th Amendment. In a 7-2 decision, the court held that it was indeed a violation of the due process clause. The court accepted that the state may have justification in fostering unity among the populace, that this particular attempt reached too far into liberty of parents to teach what they wanted, they teach the children what they wanted to learn. This was one of the very first cases in which the court found that people had liberty rights not specifically listed in the Constitution. So the freedom, and again, we're going to see it in the next case as well. The intent of the law was to suppress the speaking of German, the use of the German language by the populace, because the populace thought at least some of the people in the state believed that it was unpatriotic to speak German. The school said, well, the church said, in our school, all the people speak German. So if we're going to educate them, we need to educate them in the German language. It is part of our religion. We teach Luther's catechism. My mother's no longer with us, so she's not going to worry about me telling you this. She was born in 1921, which meant that she would have been confirmed in a Lutheran congregation in 1935 or 1936. My mother was confirmed in German. Her confirmation class, her confirmation instruction in Luther's Small Catechism was in German. That law, and that was in the state of Wisconsin, a different state, but the idea was that to understand, like many people who speak English of our age thought maybe the King James was the way the Bible was first written. There were many Germans who thought, well, maybe the apostles wrote it, but we would know about it unless Luther translated it. So we're going to use Luther's German Bible, and we're going to use Luther's German Catechism. State of Nebraska said, or the state legislature said, no, you can't do that if you're going to do it in German. And the Supreme Court said, no, that violates their religious liberty to practice religion as they feel necessary. So a very important case, 1923. 1925, the next decision, also the minority, the other group that was with the Lutherans are connected to this one as well. Pierce v. Society of Sisters, 1925. Does the government interest in the education of children include being able to force all parents to send their children to public schools rather than private schools? Or is there a sphere of privacy around the family which permits parents to make decisions about the education of their children free from government interference? That's talking 1925. Questions are still being asked in 2024. There are political ads right now about this issue. So if they're political ads, they're inherently wrong and false because they're all trying to make a point and they're all taking everything from one perspective or another. But anyway, when you hear look at some of the advertisements where it's talking about parents' rights and could this be done, should this be done, same issue from 1925. The issue was the background information, again, has to do with the use of the German language. In November 1922, the state of Oregon passed a Compulsory Education Act which required every child from the ages of 8 to 16 to attend a public school. Failure to do so was declared a misdemeanor. This law was passed largely due to the efforts of the Ku Klux Klan and the Oregon Scottish Rite Masons. And it's anti-immigrant, anti-Catholic, anti-religious. All three of those are wrapped up in the intentions behind this law. It existed as a testimony to post-World War I fears about Bolshevism and immigrants. In addition to anti-Catholicism, supporters argued that separating students into schools for different religions would lead to dissension and discord, a fear realized in parts of Northern Ireland today, other parts of the world. The Supreme Court ruled in a unanimous decision against the state and in favor of the parents in this class. The Supreme Court did, however, indicate the state has the power to require children to attend some school. So the issue is compulsory education, what can be taught in the schools, and how far religious liberty extends are these three cases. These three cases together establish, the first one is Reynolds versus the United States, allowed for the consideration of the question of religion. Meyer versus State of Nebraska supported that religious freedom could extend beyond something that was specifically listed in the Constitution. There had to be application, there had to be research, there had to be thought, they had to be looking at unintended consequences. All those things needed to be involved. And in the Society of Sisters case, it was a blatant attempt to inhibit religion. That's not in the ruling, but that was the intent of the Masons and the other people involved, the state legislature. Oregon is still, I think today, is one of the states with the lowest number of practitioners of religion. It's the highest number of people not practicing any religion is in the state of Oregon, still is, was 100 years ago, still the same way. So it's a very strong, almost anti-church, there's very strong anti-church movements within the state of Oregon. They were able to seize control, get enough votes in the legislature to prohibit, basically try to inhibit parochial education. The Society of Sisters were the ones that were named, but there are actually more Lutheran schools, there would be Catholic schools, there are actually more Lutheran schools in the state of Oregon at the time than there were Catholics. But it was the Catholic, because of the anti-Catholic element, that it was the Societies of Sisters that were named. So the Supreme Court again ruled in the question of religion. Okay, thoughts about that kind of grouping of classes. There's a connection today that I don't know enough about it, but I'll point out the connection and just tell you I'm pretty ignorant. The whole question of school choice today is an issue politically, and I really don't know what's all involved in it. Some people see it. Some people are in favor of school choice because they believe the public school system as currently constituted is not effective enough, and they don't want to stick their kids in what they see as a failing school. There are some people who use the school choice movement today as a means of getting financial aid from the state. Let me go back one step. The school choice movement is basically, let's say you live in Scottsdale, and in the city of Scottsdale, the city in your property taxes, $10,000 goes for public education for each child. So the school choice movement says, if a person says, well, I don't like the Scottsdale schools, I'm going to send my kids to Queen Creek schools. You should be able to take your $10,000 of your property tax and take it with you to Queen Creek for pay for your kids' schooling there. So that has to do with that area. That school choice area has to do with what they believe is equality of the content of education. There's another part of the free choice movement today, or school choice movement today, that believes that just because you're wealthy doesn't mean you shouldn't be able to. And originally that law was aimed at low-income people and people in negatively impacted, poverty-impacted schools. They said, well, if that's true, it should be that every parent should have the right to get their school vouchers and use it wherever they want to. So if I want to send my kid to Brophy High School, I should be able to use my tax money to pay my tuition bill at Brophy High School. The state of Arizona is in flux on this right now. There are a number of court cases challenging it, and I'm not making a political statement here, I'm making a factual statement. For the first time in a lot of years, the state of Arizona had a budget deficit last year because they severely underestimated the amount of money that would be used in the school choice program, so that the $100+ million deficit the state of Arizona had last year was all caused by miscalculations in who gets free money in school taxes. So that whole school choice movement has to do with quality of public education, has to do with status, has to do with class, and is being settled in the courts right now. In a way, that goes back, again, 100 years ago. The case in Oregon was about people shouldn't have choice. Everybody should go through the same school. Everybody should have the same curriculum. And if you believe it should be done religiously, we're not even going to let you do it on your own time, on your own dime. Everybody has to go through the same experience. That way we'll have more unity and we'll have more shared patriotism if we just have everybody go through the same education, the same kind of school. That's what was at the heart of 1925. Yes?
How does homeschooling fit into all of this?
It doesn't have an impact in the court ruling, because basically what it says is that homeschooling basically says that parents meeting certain qualifications can educate their children at home, but they're still held accountable because there are still certain standards they must meet to demonstrate that the education they're giving in the home is valid. Thank you. Couldn't find that term. Yes, sir.
Yeah, the other thing impacting a lot of this is the grading of schools.
Yes.
By my house, there's an A+ elementary school, and the cars are lined up from throughout the alley trying to get the kids in there. And then you go to another grade school, there's nobody there. So as a parent, you want to take your kid to the best school.
Right. Right, exactly. That's the whole thing. And that's another part of the whole school choice movement. And which leads to the thing, well, how do we then best distribute our resources to make sure that we have more A+ schools and less C schools? And one of the answers isn't, well, let's close all the C schools, that way we won't have the problem. I know about averaging. Yes, sir.
Oregon is kind of spooky in a lot of other ways. The first place in the Concordia College disappeared from the map, and the same people that did that turned around and sued the Missouri Synod for $300 million. And that's current, in our lifetime.
Oh, yeah, I know the people involved. The problem was, in that case, and this is really off subject, but in that case, the administration in Concordia, Portland, didn't read the fine print. And they basically did, what they did is they hired a company to do their recruitment for them. And the payoffs for those deals, the payoff in any of those schools, and there's a lot of schools that do that. I'm sure ASU has people paid in their admissions office who are out recruiting students. The problem was Portland agreed that they would pay X number of dollars per student if the recruiters met this criteria. They met the criteria. They defaulted on paying the students because they were going bankrupt. And there was an acceleration clause in this that, you have to pay us for 10 years. And if you don't meet your standard in 1 year and you close, you still owe the payments for the students that you didn't bring in for the next 9 years. And that's oversimplification. That's basically what's behind it. They went with they didn't read the detail on it. But I'm familiar with the players involved. Okay, moving on. Otherwise, we went with the Supreme Court Wilkie versus adult ed class for failing to produce. Okay, number 4, Everson versus the Board of Education. This goes again into the whole question of religious liberty. The Supreme Court ruled against the plaintiff, holding that the government was allowed to reimburse the parents of parochial school children to the costs incurred by sending them to school on public buses. Again, I want to give you some background, and this isn't in your notes. This is in my head. I'll use my own example. I went to Lutheran elementary school from 1954 through 1962. So that period of time, my whole elementary education was in Bethlehem Lutheran School, kindergarten through 8th grade, and the only state money that came into that school, this is in Wisconsin, right? Where do you think the state money showed up in Wisconsin?
Football.
Nope. The state subsidized something that they needed in the schools. What commodity are they going to subsidize in the state of Wisconsin? Milk. You could buy a bottle of milk, chocolate or white, for 2 cents. Substituted by the state of Wisconsin. That was the only state aid that Bethlehem Lutheran School had received when I was there. And I graduated in 1964, right? No school buses, no school lunch, nothing. Within the next generation, and my parents did not pay a dime in tuition because the contributions to the congregation covered the cost of the school. That was how the setup was. My daughter graduated from elementary school. She went to St. Paul Lutheran School in Ann Arbor, Michigan. So she would have graduated in about 1987, I'm guessing, right around there. They had, and Grace, my wife, was a school psychologist, and school psychologists provide educational services to special needs students. While my daughter was an elementary school student and through the 80s, if one of Grace's colleagues would have come, they would have come into St. Paul to provide the services, reading, special ed needs, psychological services, whatever is needed. The state provided that because it was provided to all citizens of the state. Whether the building was a Lutheran school or the building was a public school, by the mid-'80s, the state had recognized the state had a responsibility to have certain basic public services. Later on, it became transportation. Kids could go to a Lutheran, they could take the bus to St. Paul Lutheran School, but what they had to do is they had to go to the local public school, the nearest public school, get on the bus there, take the bus to the nearest closest public school to the school, and from there they could walk. But they could get transportation across town, but they had to do it from public school to public school because they received that. Shortly after my daughter graduated, end of the 80s, Grace and her colleagues no longer were able to go into the school to provide public school services, but the parochial school students could be taken to the schools and use the state because that way there wasn't any. And this is Ann Arbor, Michigan, very, very liberal political environment. They needed to provide the service, but they didn't have to go out of their way to do it. If you want the service, you have to come to the service. We're providing these services in these schools. So you see the change, right? My kids, I never paid a dime. Up through the end of the 1980s, I never paid a dime for tuition for my kids to go to Lutheran schools. But there were another Lutheran church, St. Luke Lutheran Church, and St. Paul. St. Paul had about 50% of this population, about 30% were from St. Luke Lutheran. The other 20% were from the Christian Reformed School on the other side of town, right? If you went to St. Luke, or if you went to Christian Reformed, you had to pay tuition to come to St. Paul. So tuition, non-tuition, free tuition, extended only to the members, right?
But you paid for some of those services through your property tax if you were a property owner.
Right, but not directly. It was indirect. Right, right, but it was always indirectly. Later on, the whole question of textbooks came into this discussion. Every student has a right to get textbooks. So many states, many school districts provide all the school textbook material to the students, no matter what building they're in. So you see how that, in my lifetime, I can go back and see how this went from absolutely no aid, and now then the principle became generally accepted benefits to the citizens. Transportation, books, school lunch subsidies. My son has two daughters, a kindergarten student and a third grade student. And he is so happy because they live in the state of Colorado. My youngest granddaughter, last year, went to preschool, free preschool, because every child in the state of Arizona, or in the state of Colorado, has a right for free preschool. So every school district has to offer full-day preschool. Now he's more excited because now Billy, the youngest one, is in kindergarten, elementary school, and the other daughter is in third grade, and they get school lunch. Every child going to public school, every child going to school in the state of Arizona gets free, in Colorado, I'm trying to keep this all straight. They all get, the state of Colorado provides free school lunches for all students and free breakfast for all students. So again, in 50 years, it's gone from no state aid to a private school. Yeah, you can start your own schools. Bethlehem Lutheran can start their own school, but you have to pay for everything. The school does, or the members of the congregation do. Two, the fact that at least in the state of Colorado, I'm sure there are other states where the state aid benefit goes to the child, and it's a concern of the state to look after the welfare of its citizens, including its youngest citizens, by making sure they have at least 2 solid meals a day. That's a radical change in where we've gone, and I don't think I know for myself, if I would have predicted what school, and I wrote part of my dissertation on this whole question. I finished that dissertation in 1990. If I would have predicted in 1990 the situation we have today, I could not have done it. It's changed that much. And the part of the driving force has always been this who's raising the question? It's this conflict, or this the conflict at the intersection of church and state has to do with school, or it really catches up with the schools in this one. So Everson Board of Education, government funding portions of religious sectarian education by having those funds apply to activities other than direct religious education. So that's where it began in the 1950s, began looking at the question of direct aid and direct question. A very important decision is number 5 on top of page 118, is Lemon versus Kurtzman. Lemon, you often see it just cited as Lemon, was one of the most important decisions made in the second half of the 20th century. And it's only way down on this list of current hearings that Lemon has been pretty much been surpassed. But for 50 years, almost 60 years, Lemon was the guiding principle for this question. So there are lots of people in America who would like to see the government provide funding to private religious schools. Critics argue this would violate the separation of church and state, and sometimes the court agree with this petition. So yeah, I'm sure there are a lot of people who would want to send their kids to private education but simply can't because of financial reasons. I saw a number a couple years ago that the tuition for sending kids to private elementary schools was higher than sending the tuition to send a kid to community college, and pretty close to the same level of tuition of state universities. So if you're going to pay that tuition for 4 years of college is a challenge. If you're going to do it from grade 1 through grade 12, and then when you've got 12 years of those tuition bills done, say, okay, now it's time to dip into the college fund. It's almost prohibitive. So there's always been people on the private education side looking to justify ways of getting funding. On the other side of the argument, there are groups of people connected to private education who still accept no money, absolutely zero money from the state, from the federal or the state government. Hillsdale College in Michigan is one of those. Is it Grove City in Pennsylvania is another one of the leading colleges. They accept nothing. And so they also don't then claim to be free of any regulations that are connected to state funding. Primarily, the biggest one is Title IX, which talks about equality. If you receive state money, any kind of state money, you're bound that you have to follow the dictates of Title IX, which says basically in the area of sports, you have to spend an equal amount of money on female athletes as female athletics as you do male athletics. If you're in a private school that doesn't take state money, you can choose, we're going to have a men's basketball team, but we're not going to have one for the women. And you can't do anything about it because we don't take any state money. So, and that's still, going on today. Yes, sir. Oh. So.
Yeah, may I ask, where do you feel the charter school system comes in then?
I'm not going to comment on that. I don't know enough. I don't know enough. I'll say I'm dumb enough not to know enough and smart enough not to try and answer a question like that without the information I need.
Tax, people property tax is supposed to go to some education. I don't understand why, depending on whatever their property tax is, a percentage of their tax that goes to.
But it's by a city.
Yeah, if you look at your property tax bill, on the back of your property tax bill, it tells you how much money goes to, like, for instance, I live in Paradise Valley School District, so it tells me how much of the money goes to Paradise Valley School District.
Okay, so I don't understand why any more money would go to a private school. Why wouldn't the same amount that would go to a public school go to a private school? Then that family would just have to pay the rest of whatever tuition.
Right. But what it does, the problem with it here, the problem with it is that the amount of money that goes into public education goes into one fund. So if the money gets paid out of that, if the 10% of the students decide we don't like the people in Paradise Valley School District, we're going to go to another school district, Paradise Valley takes a 10% hit in their budget. And is that the way we want to run our schools, by voting with our dollars to take our money? That's one of the arguments against it. But that's where the dollars come in. The dollars come in because the state then says there's a whole school funding is a really complicated issue. But the area having to do with your property taxes, that's the amount of money that you pay as a taxpayer to support the schools in the school district in which your home is located.
Right. So say my property tax for the education is $5. So if I decide not to go to that school district and I want to go to my kids to go to a different school district, why doesn't just that $5 go to another school district because they're going to be educating my child?
It does. It could.
Okay, so I don't understand.
Pardon?
That's the voucher.
Right. That's the school voucher. Right.
It costs the same amount of money to run that school that you have 50 or 70 kids.
Right,
So if 20 kids didn't move down, it's still costing the same amount of money, but that school is losing money, reimbursement for 20 kids. So that's
why
why
does it cost the same?
they have all standard over there.
Here's an easy number. You have 100 students in the school, and they each get $100 to run that. So they run their budget on that, and they have 10 teachers. 50 kids leave. They still have these 10 teachers under contract. They're still heating the same number of square. They're still cooling the same number of square feet. They're still mowing the lawn. They're still paying. So
Like that would be motivation for the school choosing the kids to up their value as far as, okay, my kids.
that's the argument. That's the argument. And the other side of that argument is that public schools must educate every child that is in their boundaries. They don't get to choose. We're only going to take the top 50% of the students, and that's what charter education. That's the argument against charter education, is they can cherry pick. They can pick the top students, which are a lot easier to educate. I'm done. Lemon versus Kurtzman. Anyway, in 1971, the Supreme Court unanimously found that the direct government assistance to religious schools was unconstitutional. In the majority opinion written by Chief Justice Berger, the court created what has become known as the Lemon Test for deciding if a law is in violation of the Establishment Clause. Here's the Lemon Test. A government can assist religion only if, one, primary purpose of the assistance is secular. I can't assist your school if you're going to use that money to buy religious textbooks or if you're going to hire a pastor to come in and preach to them. It has to be a secular purpose. You can do it to pay the water bill, but you can't do it to pay the priest's bill. Two, the assistance must neither prohibit nor promote religion. Has to be negative, has to be neutral, not negative, has to be neutral. Can't promote religion, you can't inhibit religion. And the third test is here's a good one, there's no excessive entanglement between church and state. It has to be a neat, clean handoff with no hanging chads, if you will. If the state gets entangled in the church's business, or if the church entangles it, or the church entangles itself in the state's business, it doesn't pass the test. It has to be a neutral provision. The thing that's important about Lemon is that from 1971 till 2022, Lemon was the standard that was used in all of these decisions. So the Lemon Test is very important. You can read the background there, or the next one then is Lee versus Weitzman, which is prayers at public school graduation. Nathan Bishop Middle School in Providence, Rhode Island, traditionally invited clergy to offer prayers at graduation ceremonies. Deborah Weitzman and her father Daniel, both of whom are Jewish, challenged the policy and filed suit in court, arguing that the school turned itself into a house of worship after a rabbi's benediction. At the disputed graduation, the rabbi thanked God for the legacy of America, where diversity is celebrated, and went on with that. The Weissmans were Jewish, and they were objecting to the fact that a rabbi was brought into their public school because the rabbi there turned it into a house of worship in their understanding. That was their case when they went to the Supreme Court. The court's decision, 1992, the Supreme Court ruled 5-4 that prayers during graduation violate the Establishment Clause. writing for the majority, Justice Kennedy found that officially sanctioned prayers in public schools were so clearly a violation that the case could be decided without relying upon the court's earlier church separation precedents, therefore avoiding the Lemon test. And you can read more about it there, but basically the argument was that in order to preserve this separation, even prayers at public events, even if it's rotates. If you have a Catholic, you have a Lutheran, you have a Methodist, you have an imam. Just the fact of doing that, in a sense, taints the building, taints it, and makes it into a house of worship. That was the argument, and that's what the Weissman case held, and that was in 1992. We have it up here. In 2022, there was a case that I didn't give you any information on it. The case was called Kennedy versus Bremerton. You may remember this one, Bremerton, Washington School District. Kennedy was the football coach, and the football coach regularly had a prayer after football and after football games, and the people complained about that. And in the Supreme Court ruling in 2022, voted that the prayer of the football coach did not violate anything. They threw out the Lemon test, basically, and said that, and this was an opinion written by Justice Gorsuch, historical practices and understandings should be the ruling principle. Have this been done in the past, and what is the current understandings? So when I talked about the current court going away from precedents and kind of saying, let's look at this again from the beginning and look at the historical precedents and look at this rather than at the established precedents, legal precedents, let's look at the broader context. And that's the reason Gorsuch cites in his ruling that says, coaches have always prayed with their teams, nothing wrong, no harm, no foul, let it go. But the principle clearly changed from Lemon to the Bremerton, Washington case. So that one, probably, as soon as I mentioned the football coach, a lot of you went, oh yeah, I remember that one. A couple other ones that are more current that I just want to point out a little bit. 2017, Trinity Lutheran Church, another Lutheran church, one in here, in Columbia, Missouri. The church also offered a preschool, and the state of Missouri allocated funds to provide safe, I don't know what to call it, safety, make sure the ground was safe. Put that plastic, or the rubberized, they provide all of the preschools with a rubberized pad underneath the play equipment to be safe for the children. They did not give it to private schools because they said they did not want it would violate the principle of state funding for religious education. Trinity challenged the case. Comer, it's the same guy, the Attorney General, that's where the guy that's still current, that's his name there. He was the Attorney General, and the court found in favor of the Lutheran Church that this was not an aid to religious education. What this was public aid given to all students for their health and safety. It has nothing to do with religion. So that case went pretty much like along the lines of Lemon, but didn't invoke Lemon anymore. 2020, Espinoza versus Montana, Department of Revenue. Why did I write that one down? Okay, this is I know I wrote it down for some reason. I will remember by next week why I wrote that one down. I have a bunch of cases here, and I didn't bring them all. Okay. Carson and Macon and Kennedy versus Bremerton was also, those are the ones we talked about before. The last one, Drummond versus the Oklahoma statewide virtual charter school. Sometimes you'll see it referred to as a case with St. Isidore. The Oklahoma statewide virtual charter school was an attempt by a group of Catholic bishops to establish a statewide virtual Catholic school to be funded in school choice using school choice dollars. It was supposed to start in fall of 2024, and the legislature approved funding for this program. Case went to court, and the Oklahoma Supreme Court ruled that it was not a valid case. It was not valid, that it could not fund a statewide religious school. Even though they were calling it a charter school, it was basically a Catholic religious school. It was going to be offered statewide. The archbishops, or the bishops of Oklahoma, challenged the state Supreme Court ruling, and it was supposed to go to the Supreme Court, and the Oklahoma Supreme Court changed the date when it would go into effect. Instead of being September of 2024, they made it September of 2025. So they kicked the case down the road for a year so that it could be appealed to the Supreme Court. And it would be appealed to the Supreme Court as a neutral case. Whereas if they figured it went to the Supreme Court and in one of those summary judgments, those short judgments that the court made, they could have decided, no, this is not valid, and you have to shut it down. Then they take that, if they would appeal that court's case to the whole Supreme Court, they would have come in as trying to overturn it. So instead of overturning it, they didn't start it, they put off starting it for a year so that the Supreme Court could rule on it. So that case will be ruled on, most likely, will be ruled on by the Supreme Court in the next session. Yes.
Going back to when you first started today, are you saying that after your discussion with your lawyer friends, that the current court, or Supreme Court, is going back to the original Constitution, to the constitutional principles, rather than depending upon
Precedents.
Right.
Precedents that developed over the year. In a very broad sense, that's what I'm saying. That the ruling judicial principle has been going with precedents, and unless precedent, when you're challenging a precedent, you have to break the precedents. You can't just say, well, here's another precedent, and they'll say, well, we like that precedent, but you have to prove the disutility, if you will, of the current precedent and find something that's more precedent. The current case, the current court tends to jump back and look at other principles. And again, I'll apologize for this now, and we're not going to talk much about it, and I'm going to apologize next week because it's in your handout for next week. An example would be the rulings on Roe versus Wade. That was set law for 50 years, and there's a whole bunch of cases that came out of it, and a whole bunch of precedents, and a whole bunch of practices, a whole bunch of federal regulations. There's a whole bunch of stuff supporting it. The Supreme Court, the current Supreme Court, in overthrowing Roe versus Wade, didn't disprove any of that. They simply said, here's another way of thinking about it, we're going to go that way. And that's what I'm talking about, is that this whole, the process of following precedents and arguing law on the basis of precedents was pretty much enforced in this country for 100 years. Sometimes more, sometimes less. Some courts are more activist than other courts. I remember when I was in high school and college, it was the liberal Douglas Court. They brought in desegregation, they brought in civil rights, they brought in all this kind of stuff. They brought in all these kind of things. They're terrible liberals. You look back at them now and you say, they're not really that liberal at all compared to some of the things that have changed since then. So some courts are more active, but the general principle has been the rule of law through precedence. And now it's, if you can go back and find something that's outside of that line of precedence, but you can make a cogent argument, there are enough people who agree with that principle and the current Supreme Court that have changed laws based on that. That's what they were willing to say.
Helpful to remember, in a way, that every case is two sides of the same coin. So it's always a tension between the majority and the minority. So it's always that, and all they can do is go back to the Constitution and come forward. Sure, the unintended consequences, the precedents, Brown v. Board of Education, in slavery, lots of things change over time.
Right, and how that argument gets made. Every court case is two people coming up to the same law, the same principle, the same legislation, and one side saying this is something that's good, this is something that's bad, this is right, this is wrong, this is helpful, this is not helpful. That's what it is. And they make their case, and then the 9 judges get together and they say, they discuss it. And in a theoretical world in which, all kinds of good things would happen, a theoretical world, it's a neutral discussion inside these walls, and there's nothing prejudicial or opinionated or anything in there. So we're going to, here's the situation, here are the facts, here's the discussion, we'll agree on that. That's how it's supposed to happen. On my planet, it doesn't work that way.
Isn't it better to go back to the Constitution?
Yeah, but what does that mean? What is, just saying going back to the Constitution, for instance, Lemon was a good example. Lemon basically said that there are rights and principles that people have that aren't specified in the Constitution. Because if the Constitution says, if the state of Arizona says that the legislature has reached the conclusion that females over the age of 65, because of the nature of their fact that they're women, means that they can't drive after 6 o'clock at night.
I said that. Only kidding.
There's no constitutional way you can go back and say, what does the Constitution say about driving a car? But you go back and say, what does the Constitution say about regulating the basis of activities based on gender with anything else? That's what you're trying to say, is what does the Constitution, which doesn't, there's nothing that's happening in our country today, mechanically, physically, that was the same as it was 200 plus years ago. So the question is, what are the principles derived at that time? How do you apply them in this situation? And I hope bring this. Sometimes you get at the end of a sermon, you're way out here someplace, at the end of the line. How do I get back here today and wrap this up? The basic principle we've been trying to talk about today is that a lot of these discussions about how government works and how our interaction together have to do with the intersection of religion, intersection of church and state, because religious concerns are almost inherent to the nature of God's people. Our religious sensibilities shape how we view everything. And so it would be ludicrous to think that our religious understanding and our religious thoughts can't have to be completely separated. Last week, if you want to, again, it would greatly enrich your experience next week if you read through chapter 6, or you read through lesson 6, before that time. The question I'm going to be asking is, who speaks for the church? And I'm going to be giving you a handout next week that puts this in. I don't want to get too far ahead of myself. Takes a look at this. And one of the things we're going to have to understand, we talk about the church. We talked about this a little bit in week 1. We're going to come back and talk about this in week 6. When we talk about the church, are we talking about the body of Christ, which means all those who are believers in Christ? Are we talking about this corporation that's known as La Casa de Cristo Lutheran Church Incorporated, registered to do business at 6200 East Bell Road in Scottsdale, Arizona? Are we talking about the group of people that we hang around with that are the church with us? What are we talking about? And when we talk about, so me, and I've put a disclaimer in here, I'm not speaking on behalf of anybody officially in position at La Casa de Cristo Lutheran Church. But does that not mean that I, who happen to be a member of La Casa de Cristo Lutheran Church, might put a sign up in my yard advocating the person I think should be elected to be the next president of the United States? What if I put that same poster up in front of the pulpit, or put an advertising on the back of Pastor Jeff's shirt it's a completely different thing, right? I can wear a t-shirt that says 50 years. I'm not going to wear one that says something that would advocate. I'm not going to say advocate one candidate or the other. So how do we sort that out? Who speaks for the church and when? And the answer to that question is 10:30 next Sunday. We'll see you all there. Let's close with a word of prayer. Heavenly Father, we thank you for this country. We thank you for the rights and blessings we have as citizens in this country. We thank you also for being called to be children of God, to be members of the kingdom of Jesus Christ. So Lord, as we live out our lives in both these realms, we pray that you would bless us, that we might continue always to love those who don't know Jesus and to continue building those who do. Bless this endeavor in Jesus' name. Amen. Have a good week, and we'll see you next week when we wrap it all up.